office is appropriate, you can go out and show it to the arbitrator. Closing arguments. I think you should make a closing argument to the arbitrator. If you're not asked to do so by the arbitrator, request that you be allowed to. The closing statement should be the counterpart to your opening statement, which was the counterpart to your brief. A short, sweet recitation of what you want, why you're there, and what you want the arbitrator to do. And that should be the last thing that you say to the arbitrator. Therefore, I request the following. So that's the last thing the arbitrator should write down in the notes. There should be no question as to what remedy you're seeking there.
And remember, in most of these, you're talking about money. So don't be afraid of saying, I think this case is worth X dollars. But when you're going to give them a figure, be realistic. Don't blow it out of proportion because you've got somebody that's been there before and you're not going to be able to blow any smoke at them.
Final briefing. The arbitrator can request that you file briefs. There's no specific rule dictating what they should contain or what the timing of it is. If you think it's appropriate to brief something, request that you be given the opportunity to do so. Again, whatever you submit should be short and sweet and easily understandable by the arbitrator. There is one caveat here, and that is the arbitrator is limited by Rule 1615B to give you a decision within 10 days after the termination of the hearing, the closing of the hearing. So if you need more time than that to brief, or you need about that time and that doesn't leave the arbitrator enough time to come to a decision, then you ought to request an adjournment of the hearing under 1614A2, which simply means that the hearing gets continued for the purpose of briefing, and then once the briefs are in, the hearing is concluded. You don't have to show up. It just happens fictively, and then the 10-day period begins to run after that.
Okay, the one other thing I'd suggest you mention to the arbitrator, especially if it's outside of San Francisco, because there is no standard form of an award form, is you're recovering your costs. There's a bit of a problem here which we don't know the answer to. The arbitrator makes an award under the statute. The county clerk, if no request for trial de novo has been filed within 20 days after the filing of the award, on the 21st day enters a judgment based on that award. The arbitrator is without any power to do anything once that's happened. And if the arbitrator has not awarded costs, it is unclear whether merely filing a cost bill is going to allow you to recover costs. Perhaps it won't. So you should ask the arbitrator to also award you costs. Now, it isn't necessary, although it's preferable, it isn't necessary at the hearing to have your costs itemized and get into a hassle, is this a recoverable cost or not. Some places prefer that, and I think probably on balance it's a better way of doing things. But at the very least, what you should have is a request to the arbitrator that when you make your award, please include within it that I also recover my costs. If that happens, and then that's entered as a judgment, then there can be a cost bill filed, and if there's a hassle on it after that, in our court, the law and motion judge will resolve that dispute as to whether or not a particular cost is a recoverable one or not.
Judge, I think that latter point is certainly, from the practical point of view, much more desirable, and that is just ask for your costs, file your cost bill, and then if the other side doesn't like it, they can file a motion to tax costs. You shouldn't ask the arbitrator to sit there and decide what is and what is not reasonable and recoverable. I think you're going to create more problems than you'll ever solve. Ask for your costs and make sure you include that in the award, or you see it included in the award.
And you remember, because the arbitrator loses jurisdiction, and once that award is filed, let's say they file it on the 10th day, they can't do anything after that, and you get your copy and see there's nothing in there about costs. You could be in trouble, because again, in these smaller cases, if you had to do much discovery, you may well have an amount, given the value of the case, that really shouldn't have to come out of your client's pocket.
It's like the TV commercial. You can deal with the arbitrator now, or you can deal with Judge Brown later. I think the choice is self-evident.
Yeah, and I'm not sure there is a real question a serious question. If the arbitrator has not awarded costs, whether the court can thereafter. It's a very serious question, and we don't know the answer to that, really.
We again remind you that accompanying this tape is the printed softcover booklet that